Hello and welcome to Sarat Chandra IAS Academy, where your dreams are our mission. This is Yatharth here. So today we will be discussing about governors' inaction upon bills or bills that have been passed by the state legislative assemblies. So we'll see who is the governor and what is the issue associated with this topic right now. So I have taken the context from this editorial which was published today in the Hindu, the importance of the constitutional punctuality. So this editorial is also important and we'll be reading this in another video, which will be the second video of this series. So we'll see this editorial later. It has some different points. For now, we need to cover the context and basic portion that I have covered in this video. So let's see. First of all, let us deal with the static portion, which means who is governor, what is the powers, authority, oaths, etc. So which is the basic syllabus for polity. So let's see. So what are the constitutional provisions associated with the governor? So the governor's office, appointment and powers are mentioned in Article 153 to 162 of the Indian Constitution. So these are some things which I am telling here, which you should note down. And if you know already, of course, then you should just revise. In case you don't know or haven't read them, then just point out one note that governor, Article 153 to 162. So just like this, you can create short notes also. Alright, so appointment is directly by the President of India and serves at the pleasure of the President. What are the powers and functions? So the governor's powers and functions are primarily related to the administration of the state, including appointing the chief minister, calling the assembly session, and giving assent to bills that have been passed by the state legislative assembly. The governor also has some discretionary powers, including the power to reserve bills for the consideration of the president. So this is what we are mostly talking about here. Let us see. So in the Indian system, let's assume this is India. There are two governments. One is central government and one are the state governments. And the state government system or administrative system is basically one kind of replica of what happens at the center. So there is president here, there is prime minister here, then there is Rajya Sabha and Lok Sabha. So in the same way, there is governor here, and the relation that president shares with the prime minister is also shared by between governor and the chief minister. And many states have two assemblies, upper house and lower house, but mostly have one state legislative assembly. So this is basically one form of replication of the government that is administrating the states. So what we see here is the role of center-state relations. So governor plays a crucial role in center-state relations, including the power to recommend president's rule in the state and the power to make a report to the president regarding the failure of the constitutional machinery in the state. So what we consider usually that the CM and the SLA, that is State Legislative Assembly, is exclusively the state government. The governor is, however, considered to be a part of the central government's administration or a relation builder between the both governments. This is why the post is very critical. What is interference in state politics? So the governor should avoid interfering in the state politics. That means whichever policies and bills are being passed by SLA should be passed directly by the governor and should act in non-partisan manner. Non-partisan manner means not favoring the central government's policies or the state government's policies in any manner. However, in some cases, governors have been accused of overstepping their limits and interfering in state politics. So let's see one of the controversies related to this only, that how the governor is able to step in the state politics. So the recent controversy surrounding the Tamil Nadu governor. So Tamil Nadu Governor R.N. Ravi Actions regarding the passage of the bills in the State Assembly has led to a resolution being passed urging the President of India to intervene. That means the SLA is passing some of the bills and they are not being passed by the governor. So, several bills passed by the assembly have been pending as the governor has not made any decision. The assembly passed a resolution. Which assembly? State Legislative Assembly. Passed a resolution urging the President of India to fix a timeline for assent to be given to the bills passed by the assembly. So, this is the problem, that a timeline is not fixed. So, this is the problem of the constitution here. In the next video, we will see why this problem comes, or what is the origin of this problem. Just a second. All right. So this has raised questions over discretionary power of governor with respect to the unlimited delay in giving assent to the bills which are duly passed by the state legislature. So let's see what is this discretionary power given or granted to the governor. So the constitution makes it clear that if any question arises whether a matter falls within the governor's discretion or not, the decision of the governor is final. That means governor is having an upper hand here. And the validity of anything done by him cannot be called in question on the ground that he ought or ought not to have acted in his discretion. So what is discretion basically? Discretion in Hindi it means vivek or swavivek. That means based upon his own thinking. What seems right to him. So there are two types of discretion. Constitutional discretion, that means reservation of a bill for the consideration of the president under Article 200. Which means the governor can reserve a bill which have been passed already by the state legislative assembly saying that I have withhold it for the consideration of the President of India under Article 200. Second thing is recommendation for the imposition of the President's rule under Article 356. So one of the emergency articles. Also, while exercising his functions as the administrator of an adjoining union territory in case of additional charge. Other than that, determining the amount payable by the government of Assam, Meghalaya. So this is not very important for us. Seeking information from the chief minister with regard to the administrative and legislative matters of the state. So these are not much used. What is much used is delaying the passing of bills, keeping them for president's consideration for indefinite period of time. So this is basically, let's say center is not happy with something that a state is coming with due to the political reasons. So the central government will signal the governor of any state to not pass or not let pass a bill which has been passed already by the state government. So governor will not let it pass. So it's basically indirectly politics which is between center and the states. So it's a loophole in the state center federalism, which also gives us the way forward for this. We'll see it later. So what are the situational discretion? Situational means when the situation such arrives that the discretion of the governor is necessary. So let's see this. That appointment of chief minister when no party has a clear-cut majority. So that is based on the governor's discretion. Or when the chief ministers in offer dies suddenly and there is no obvious successor. Dismissal of the council of ministers when it cannot prove the confidence of the state legislative assembly. So these are some situational discretions which power are with the governor of a state. Dissolution of the state legislative assembly if the council of ministers has lost its majority. So one question arises that can the governor withhold his assent to a bill in exercise of his discretionary powers? So with the plain reading of Article 200 suggests that governor can, that means the answer is yes, withhold his assent. Experts question whether he can do so only on the advice of council of ministers or not. The constitution provides that the governor can exercise his executive powers only on the advice of the council of ministers under Article 154. The larger question is why governor should be allowed to withhold assent when the bill is passed by the assembly. So this is the larger question, that why governor is playing a role at all. The Supreme Court of India recently commented on the provision of Article 200 that governor should not delay over bills sent to them for assent after they had been passed by the legislative assemblies, because that is the will of the people, just as we talked in the Keshwanand Bharati case also. So one thing is, of course, connecting to the other. If you watch all the videos clearly, you will develop an understanding about how the system or the government is working. So what are the challenges involved in this? One is delay in decision making. So the governor's failure to take a decision on the bills passed by the legislature leads to a delay in decision making, which affects the effective functioning of the state government. Second thing is delay in implementation of the politics or policies and laws. So when the governor fails to make a decision on a bill passed by the assembly, it delays the implementation of the policies and laws. So this is also a part of the politics. This delay can have significant consequences, especially when the bill is related to public welfare. Usually it does not happen that the bills related to public welfare are not passed. Most of the bills that are so not passed mostly are of nature which may create a conflict with the between the state or central government, their individual policies. Another thing is it undermines the democratic process. So the governor who is appointed by the center can use his powers to delay or reject bills passed by state assemblies for political reasons, which undermines the democratic process. So what is democracy? Again, we saw earlier also that accuracy by the demos, and demos means people or the public. So the representatives in the SLA, whichever are making bills or passing them, are the direct election of the people, directly elected by the people, and they are coming up with some policy for the people, whatever are their subjects in the under the state laws. So this makes a clear loop. That means people choose some representatives, they come up with a policy for the people on the subject that have been allotted only to the state laws or state list. Then what is the issue with someone who has been appointed by the central government to disturb this process or interfere in this process? Why withhold a bill which was supposed to be passed and to be applied in the public for the assent of the president, and that too indefinitely? So the public often views pending bills with the governor as a sign of inefficiency or even corruption in the state government, which can damage the government's reputation. That means the public thinks that if the bill is not being passed by the governor or the central government also indirectly, then there must be something wrong with the bill itself or the government itself. So it decreases the confidence in the government, the public confidence, which is very required for any functional government to have. All right. So what are the constitutional ambiguity? So there is ambiguity in the constitution regarding the governor's power to withhold assent. What is ambiguity? Ambiguity means no clear cut. In the UPSC also, in the prelims also, you will be seeing question like, is this term defined in constitution? Is this term mentioned in the constitution? There are many terms which are mentioned but not defined. There are also terms which are neither defined nor mentioned in the constitution. So should make a list of these both and focus on what is defined, what is not defined in the constitution. So whenever there is a line, you see such a line, then you can note it down that there is an ambiguity in the constitution regarding the governor's power to withhold assent. So although the constitution grants the governor the power to withhold his assent, it is unclear whether he can do so only on the advice of Council of Ministers. Also, the second thing is the time is not clear for how long he can withhold the assent. Another thing is a lack of accountability. So when the governor withholds assent, he does not provide any reason for his decision, because that is the basic premise of discretionary power. that it's upon my discretion and there is no need for any reason. So this lack of accountability undermines the principle of transparency and accountability in the governance. Let's see what is the way forward. So firstly, we are talking about the time frame for assent. So the Supreme Court can consider fixing a reasonable time frame for governors to take a decision on a bill passed by the assembly in the larger interest of the federalism in the country. This can prevent undue delay and ensure that the governance of the state is carried out in accordance with the constitutional provisions. Other things are center-state dialogues. This both I will explain now, and public awareness and activism. So let us see the gist of the matter. And how to address this matter also. So what we saw is that in India, so there is a central government, and there are various states. So there are state governments. Now, the people of the country belong neither to any specific center or any specific state, but to the nation. And the nation belongs to the people. So this is the loop that needs the administration. And now there are considerably three branches of the administration. One is legislative, one is executive, and one is judiciary. Now what's happening, why the issue is coming, is because the legislative parties are two. One is central again, and one is state again. And while the subjects are divided, they also overlap somewhere. So there are policies which a state government can make, which can go against the policies of the center, and there are policies which a center can make, which can go against the policies of the state governments, memorandum or their election campaign promises or whatever. So however they want to administrate their individual state. So there is one connecting link between both, whether it is center and the state. The connecting link is governor. So there are, let's say, bill passed in the state assembly. The governor can withhold his consent or reserve it for the president. And president, let's say if the question arises that what is the relation of the president with the center, then president is also very much influenced by the central government's power or their policies. This is one thing. Now, when we talk about the federalism, so that is why the solution lies in the center and state dialogue, which is one way forward. The maintenance of the federalism is very important for us, for the welfare of the people. But let's say if politics does not allow this, if politics does not allow them to be coherent, then who is going to interpret the constitution? If something is not defined in the constitution, does not mean that it will never be solved. There are always new issues arising and always new issues being solved. So the final interpreter of the constitution is the Supreme Court. So Supreme Court will decide finally that whether governor can act so in discretion without the advice of the Council of Ministers of the State Legislative Assembly, and for how long the governor can withhold the assent. And what is the power of governor in fact to withhold or give this assent to the president? Why is he doing so? So this is a question for Supreme Court. Now what is important for us from here? One is the concept of the federalism. Second is a clear understanding of the post, power, appointment and oath of the governor and his relation with the center and state both. And our third and most important thing is the power of the judiciary or Supreme Court in this aspect, that what it can do by solving this issue. So this can be important for us in both mains also and interview also. Also, you should see that how the governor and the president connect to the central. So these are the things. So I hope you learnt a lot from this lecture. We'll be reading an editorial in the next video. So we'll see what are the concurrent solutions to this in the other part of the world also, and why this problem arises in the constitution itself. What was the origin of this problem? So that will be for the next video. For this video, I'll sign off. This is Yatharth here. Thank you very much. Have a good day. Keep studying and be bright.